On the record in the matter, the people of the state of Michigan versus Gilbert Fernandez Rodriguez, second, 24-03799. Yes, please.
Good morning, Your Honor. Matt Nagel for the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Rodriguez, who is present and standing to my right.
This matter was scheduled today for preliminary examination and securing a concealed weapon. How are we proceeding on this?
Your Honor, I was informed on Monday and I reached out to parties on Tuesday regarding my main witness in this matter. My officer witness, who's the primary witness in this case, was scheduled to teach a class today, and so because he's unavailable due to officer training, the people are going to ask the court to find good cause to adjourn this just to the next available court date. We don't need too much time.
Thank you, Your Honor. Yes, I was on that email chain from the prosecutor, and I do appreciate the heads up. We would not be consenting to it as the defense, but we would leave to the court's discretion just for the timeline preservation. Thank you.
Okay, Mr. Rodriguez, you understand that you have the right to have your preliminary examination within 21 days of the date that you were arraigned. Okay. Okay, and so the prosecution is not prepared to proceed today because the officer has a scheduling conflict, and so the court's going to note the objection or lack of consent to adjourning this, but the court is going to find good cause to go beyond the 21-day timeline to reset this so that the officer can appear. You have any questions about that? February 13th at 8:30. February 13th at 8:30. Vision report date will get your notice to appear. Any additional matters for the record?
Not for the people. Thank you, Your Honor.
Not for the defense. Thank you.
Record in the matter of the people of the state of Michigan versus Joshua Fletcher, 24-03795.
Good morning, Your Honor. Matt Nagel for the people.
And Assistant Public Defender Sarah Donnelly on behalf of defendant Joshua Fletcher, who is to my right.
Okay, today was the date and time that was scheduled for a preliminary examination for carrying a concealed weapon. And my notes indicate that there is going to be an unconditional waiver to the circuit court. Is that accurate?
That's accurate, Your Honor. It's the people's understanding that the defense is going to choose to waive their right to hold a preliminary exam. People would also waive their right. That'd be an unconditional waiver. And for the record, there was an offer on this that in exchange for a guilty plea, and the circuit court people would not object to sentencing under IDA.
That's accurate.
Yes.
Okay, and then Mr. Fletcher, you understand your right to have a preliminary examination in the district court. You understand that the purpose is to require the prosecution meet their burden of establishing that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with a crime, that crime being a felony. You understand that? I'm sorry? And you wish to unconditionally waive your exam? Or do you want me to explain the unconditional part? Yeah, unconditional meaning there's no promises or nothing that's enticing or inducing you to waive it or give up that exam. Because if you get to circuit court and let's say you don't get HYTA status for some reason, or you don't think the negotiations are going the way that you want, you can later come back and decide that you want to have your exam. So you're giving it up freely and voluntarily, not based on any conditions. You understand that? Okay. Anyone threatening you to do or to waive your exam? Have there been any promises extended if you waive your exam? Okay, bind over date's going to be January 29th. That's the date that the circuit court's going to get the file from the district court. You do not need to appear in circuit court on that date unless Mrs. Donnelly files some motion for you to be rearranged there, okay? Without that, your next court date will be a pre-trial in the circuit court and your attorney will be made aware of that. Do you have any questions for the board at this time? Has your phone number changed since the time that you were arraigned? What about your address? Okay, your bond was set at 2,000 personal recognizance that will continue. Any additional matters for the record?
No, Your Honor, thank you.
Not for defense.
You're all set. Record in the matter of the people of the state of Michigan versus Kevin Uzinger, 24-02739. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
And good morning, may it please this honorable court. Michael Nichols on behalf of Mr. Kruzinga. Mr. Kruzinga is present and he's to my right.
Okay, today was the date that was scheduled for preliminary examination. Are we ready to proceed today?
Your Honor, the people have been in touch with the victim in this matter. Based on my conversation with the victim, the people are going to nolly counts 1, 2, 4, and 5, but the people are otherwise prepared to continue with counts 3 and count 6.
Counsel, can you approach, please?
Yes, Your Honor.
Not related to this, just has nothing to do with you. I just need your name printed on those ollies.
Oh, shoot. Thank you.
Well, I'll help you get some steps.
Okay, let's see. Okay, so obviously there's no objection to that, correct?
Right.
Counts 1 and
Thank you.
counts 1 and 2, correct?
That's correct. And then the felony firearms that go with those 2 counts, Your Honor. So that's 4 and 5.
Okay, those will be dismissed. So we're proceeding on count 3 today.
Yes, that's correct. For the purpose of the preliminary exam, that's correct.
Okay, sounds good. Any other preliminary matters?
Just one, Your Honor. I do have a witness who is present and therefore people are ready to proceed, but I have another witness, Officer Daniel Foote. He's in the process of finishing up the serving of a warrant. He's part of the START team, so I may ask you for a brief recess while we wait for him to arrive. He informed me that he should be here between 9:30 and 10 o'clock.
It's 9:26. So
He's here shortly.
should be here shortly. You can proceed.
Thank you, Your Honor. That people would call Officer Christopher Mosby.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I swear.
Thank you. You can have a seat. You can state your first and your last name and then spell both.
Christopher Mosby, CHRISTOPHER MOSBY.
You can proceed, counsel.
Thank you, Your Honor. Officer Mosby, can you tell the court with whom you are currently employed?
The Lansing Police Department.
How long have you been employed with them?
Been employed there for about 2.5 years now.
What are your primary duties with LTD?
I'm a patrol officer.
What are some of the things you do as a patrol officer?
Respond to calls for service.
And were you working in that capacity on September 11th of 2024?
Yes, sir.
Were you, did you respond to any dispatch that night?
Yes, sir.
Can you tell the court where that was?
Mercantile Way,
And
Can you repeat that, please?
or where what was?
the location you were dispatched to?
In this instance, I was dispatched to 6245 Mercantile Way. That area.
Can you spell that, please?
MERCANTILE.
Thank you.
And was that in the city of Lansing,
Yes, sir.
County of Bingham?
Yes, sir.
What was the reason for that dispatch?
Originally, I was dispatched to a possible drunk driver. Someone said that they saw a silver Toyota vehicle like that had some front end damage to it.
Back to the hearsay at this point.
Okay.
It's not being offered for the truth of the matter, sir, Your Honor. It merely explains why the officer dispatched to the location.
Judge, you don't move.
So I was dispatched because someone called in saying they saw a silver Toyota vehicle that had front end damage. It looked like they may have hit something.
And to be clear for the record, this was not an OWI investigation that you had witnessed prior to a traffic stop.
No, sir.
So what did you do when you received that dispatch?
When I received that original dispatch, I started just regular traffic driving to that location.
And what did you observe when you arrived at that location?
So before I arrived at that location, a call escalated. But so when I arrived at the location, there was no vehicles there initially. So then I drove around the building. And then when I drove around the building, I saw a silver Toyota Tundra parked in the middle of the road in front of it. So then I got behind it and saw an individual standing right outside the driver's door.
So that individual was not inside the vehicle at that time?
No, not at that time.
What did you do at that point?
Because the call ended up escalating to possibly a weapons incident, I ended up conducting a felony stop on the vehicle, asked the individual, and I later identified as Mr. Kuzinga, put his hands up, complied, handcuffed him, put him in the back of my car, and went on my investigation.
And did you speak to Mr. Kruzinga?
Yes, sir.
What did he sound like to you?
Yeah, some slurring of his words. He sounded a little bit confused as to what was generally going on when I was trying to talk to him.
Can you tell the court what you mean by slurring words?
It's when he's slurring words like how I'm enunciating clearly right now. It was more like a kind of like that.
So for the record, you're imitating the slurring of words.
Yes, sir.
Okay. Did you observe anything else about Mr. Kruzinga?
So when he faced me, I noticed that it was like a wet spot on his pants. And then when he got closer to me, I smelled like urine. So
did you smell anything else?
it smelled like intoxicants or alcohol on his breath. It was just he smelled of alcohol.
Did you observe anything else physically, anything with his eyes or the way he was standing or anything else that might be relevant to an OWI investigation?
He stumbled a little bit when he came towards me and his eyes were a little red.
Okay. Did you conduct any roadside tests at that time?
No, because it was a possible violent incident that just occurred at the time of the incident, and we weren't in a secure environment, and it was possibly just in an accident, so I didn't think it was appropriate to conduct SMS.
And the truck that was there, did you describe that truck for the court?
Oh, it was like a silver Toyota Tundra. It had heavy front end damage, like disabling damage to it, like it hit something pretty hard.
And was there anybody else in the vehicle when you arrived?
No, sir.
Was there anybody else around the vehicle when you arrived?
No, sir.
And when you observed Mr. Kruzinga, I think you testified that he was not in the truck?
No, he was standing right outside the driver's door when I came around.
And standing outside the driver's door, do you remember whether or not the door was open or closed at the time you observed him?
The door was open.
And so having made these observations and because the nature of the call was probably more serious than a mere OWI, what did you do with Mr. Kruzenga at that time?
That's when I called him back to my patrol vehicle, handcuffed him.
Did you get a good look at him that night?
Yes, sir.
If you were to see him again, would you recognize him?
Yes, sir.
Did you see him in the court today?
Yes, sir.
Can you point to him and identify an article of clothing, please?
He's wearing like a burgundy tie.
And may the record reflect that the witness indicated the defendant at the counsel table and for the record reflect ID?
Any objection?
I don't object.
So noted.
Thank you, Your Honor. Did the witness indicate that anybody was available to move his truck for him after you took him into custody?
I object as to the form of the question. I'm not sure when he says witness. Who he means.
Oh, I beg your pardon. No, that's correct. I'm going to rephrase your name.
Thank you.
Did the defendant indicate anybody was available to move his truck for him since he had been taken into custody?
No, not her.
So since this was a potential, did you find probable cause at that time to take him into custody for OWI, potential OWI?
Yes, sir.
And because the defendant was potentially intoxicated, and I think you testified that there was nobody else available or nobody else present at the time you interacted with him, what was your next move to do with that truck?
It was in the middle of the roadway, so we were going to tow it.
Okay. And is it standard procedure to inventory the truck before it is towed?
Yes, sir. We conduct the inventory search.
I have no further questions for this minister.
Okay. Off the record, can you-
Thank you.
I'm back on the record. Crawford.
Good morning.
Morning.
At the time that this happened, which was September 11th of 2024, you would have been a sworn police officer for about 2 years. Is that true?
I'll see you.
Testified before today?
Yes, sir.
If you don't understand a question, you know the drill. Just let me know and I'll rephrase it for you.
Okay.
Otherwise, need at least a yes or a no, right?
Yep.
Okay. I don't know how to spell what you articulated when you were mimicking Mr. Kruzinga, but we got to make a record. So we may need you to spell something or make sure to articulate things, all right?
Okay.
Okay. Officer Mosby, you did a police report in this matter, correct?
Yes, sir.
You were the first one to make contact with Mr. Krasinga. Is that also correct?
Yes, sir.
You were wearing a body worn camera that night, true?
Yes, sir.
And I noticed when I looked at all the body worn cameras, and there were a lot of them, looks like you turned yours on after you had Mr. Krasinga in handcuffs. Do you recall that?
I do not recall that, sir.
Have you looked at your body worn camera prior to testifying today?
No, sir.
Have you reviewed your police report prior to testifying here today?
Yes, sir.
Is the police report an accurate memorialization by you of the important observations of the night?
Yes, sir.
The initial call you indicated was concern about a vehicle that had damage to it, true?
Yes, sir.
Damage that you may have observed to this vehicle may not have come from that night, true? You don't have any training in how to assess the freshness of damage to a vehicle, right?
No, sir.
And I take it that had you asked Mr. Krasinga about when that damage occurred, you would have put that in your police report, right?
Possibly. Yes, sir.
It's not in your police report, is it?
No, sir.
Not in your police report. It didn't happen. Didn't mean the conversation, right?
Not completely, sir.
I don't understand your answer. Let me put it this way. You didn't ask Mr. Krasinga about the freshness of the damage to the vehicle.
I cannot recall, sir.
If it's not on your body worn camera, it didn't happen, right?
Objection has been answered.
Do you want to respond to the objection?
Police report was what I asked about first. I just asked about body worn camera.
Objection removed.
Would you trust me that it's not on your body worn camera, the conversation with Mr. Krasinga that I just asked you about?
No, I wouldn't, sir.
You wouldn't trust me?
No, not on that. I may have just not thought it was relevant to put in my police report. That's on my behalf, but it's a possibility I could have asked.
So do me a favor between now and when we have a trial in circuit court, did you review your body worn?
Will do, sir.
The nature of the call escalated was your testimony on direct examination, correct?
Yes, sir.
I think you used the term weapons violation,
A weapons incident.
a weapons incident. In fact, that maybe shots had been fired, right?
Yes,
In the direction of, and I think it's pronounced Mercantile Way, in the direction of Mercantile Way, where you were headed, right?
yes, sir.
And when you got out of your car, your gun's drawn on the person you see, right?
Not on the person. I was at the low ready.
Okay, so it's at the low ready,
Yes, sir.
so your gun's drawn, yes?
Yes, sir.
Okay, maybe not right at Mr. Krasinga, but it's drawn, right?
Yes, sir.
And you don't take your gun out every shift, do you?
Not every shift, no, sir.
And when you take your gun out, no matter how many times you've done it over 2 years, you're getting a little excited, true?
I would say so.
Right. And then you're the first one there, but I think it was Foot is right behind you, right?
Yes, sir.
I think you guys almost, there was some conversation, I think on Foot's body, you guys almost collide, right?
I don't recall that, sir.
Okay. And then Foot's right behind you, then a bunch of other patrol units are right behind you guys, right?
Yes, sir.
There were at least 10 LPD cops out there, right?
I would say about that.
Because you guys are responding to the possibility of shots being fired, true?
Yes, sir.
And when you make contact with the person who you've identified in court as Kevin Krasinga, you tell him, turn around, right?
Mhm.
I'm sorry.
Yeah, yes. You said, I need to know if that's
Yes,
yes.
yes.
You tell him, turn around, right?
Okay.
And you're not speaking, as you put it on direct examination, calmly and articulately. Your voice is raised, correct?
Yes, sir.
You're yelling at this guy because you're concerned, right?
Make sure he can hear me. Yes, sir.
Turn around, walk back toward me, right?
Yes, sir.
And Krasinga is the guy you're interacting with is yelling back to you, right?
Can't recall.
Okay. True, he wanted to know what he did, right?
Most people do.
He's yelling at you, what did I do? What did I do? Right?
I cannot recall, sir.
And you're telling him back up, back up, back up multiple times, right?
Yes, sir.
And the reason to tell him to back up was because you were going to put him in handcuffs.
Yes, sir.
You're going to at least seize him for purposes of investigating what's going on, right?
Yes, sir.
And while you're doing that, over to your right, there are 4 LPD officers in that, as you put it, silver Toyota Tundra, right?
At what point in time, sir?
As you're getting Krasinga to back up and you're putting him in handcuffs, those 4 guys run into that truck.
Just to make sure there's no other people inside the vehicle.
And they open up the doors, right?
I can't recall, I wasn't part of that team.
If that's on, if not your body worn camera, somebody else's body worn camera, the video speaks 1,000 words, doesn't it?
Yes, sir.
Okay. And so this is what's going on. These 4 guys get into that truck as you're putting this gentleman under arrest. True?
I cannot speak on that.
You don't remember seeing it?
Well, I was talking to Mr. Kuzingas, and I was not part of the team that cleared the vehicle, so I directly cannot speak on that.
How many times have you testified before?
2 or 3 times.
Okay, let me just parse this out with you. I'm not being personal. I just want to, we got to make a record here. And it's called the crucible of cross-examination. Okay, officer?
Yes, sir.
Okay. That truck,
Mhm.
while you've got this gentleman backing up toward you, is how far away from you?
I'd say about 15, 20 feet.
And during this situation, based on your training in the police academy, you went to the police academy, right?
Yes, sir.
And you're trained on, what do they call it? Critical incident situations,
Yes, sir.
shots fired situations?
Yes, sir.
And you're supposed to use all of your senses, correct?
Yes, sir.
Your vision, including your peripheral vision,
Yes, sir.
your sense of hearing, right?
Yes, sir.
And your sense of smell, right?
Yes, sir.
Because you've got to see what's going on, as you put it. Maybe there's somebody else in that truck, right?
Yes, sir.
Who fired those shots is what you guys are trying to figure out.
Yes, sir.
Okay. Is there still a threat at this moment, right?
Yes, that is a concern.
And that's probably one of the reasons why your voice is elevated. True?
At the moment when I was talking to Mr. Kuzinga after having secured notes,
Okay, so let's back up. How far did you say you think that truck was from?
Objection, asked and answered.
I just want to clarify it.
maybe 15, 20 feet.
Okay,
Objections on the wall.
so 15 to 20 feet away, maybe from here to the corner of the courtroom, right?
I'd say a little bit further than that.
Okay. A little bit further than that. You can see what's going on over there, right?
If I were to be looking over there, yes, sir.
Okay, and other cops are giving other cops directions, right?
Yes, sir.
Because some guys have more experience than other guys, right?
Yep.
And gals, right?
Yep.
And you're using your peripheral vision, right? You're not going to tell me you weren't.
Yeah, can't, not in my peripheral vision, sir.
Okay, so you can see there's a group of officers going to that truck, right?
Objection,
So if I-
asked and
There's an
objection,
objection.
asked and answered. This would be the 3rd time counsel has asked the witness whether or not he saw other people going to the pickup truck.
Counsel, did you want to address that?
I don't think it's the 3rd time.
What about the second time?
Might be the 2nd time.
Well, then the ask and answer is sustained.
Are you going to adopt as your testimony that you could not see or you could see?
Dealing with Mr. Kuzinga, I was searching him or patting him down before putting him in my patrol vehicle. Like you said, the situation is developing rapidly, and I'm trusting my coworkers to do their job, so I don't need to concentrate on the truck.
You know that one of those coworkers is Officer Foote.
Yes,
So if his body worn camera shows this court, the finder of fact for this premium, that at least one or more officers are getting into the truck while you're dealing with Mr. Krasinga, it is what it is, right?
Objection, it would be beyond the witness wouldn't have any personal knowledge as to what is or is not on Officer Foote's body worn camera.
I don't think that's a valid objection. I mean, you can say whether it may be there, whether he's looked at it, that he hasn't answered that question yet.
Well, he could answer if he is aware. If he doesn't know, he can answer that too. It's all the objection. Maybe he looked at someone else's camera. I don't know.
no, not with the officer for the body.
And you don't have any independent recollection of whether you saw anybody getting in the truck because you were dealing with Krasinga, true?
Yeah, at the time when I was dealing with Mr. Kuzinga,
Observations that you made as you approached this vehicle, you testified to on direct examination, right? Covered everything?
everything about me seeing the vehicle.
Yeah, well, let me put it this way. Let me parse this out for you.
Okay.
When the prosecutor asked you about your observations relative to an operating while intoxicated,
Mhm.
you covered everything, right?
No, I wouldn't say everything.
Um, As of 9/11 of 2024, how many drunk driving arrests you had?
I think two.
This would have been your third
Are you talking about from that point or before that point?
on the day that you encountered Mr. Krasinga. How many drunk driving arrests?
Oh, well, that'd be,
Is this your first?
no, that'd be probably like 10 or 12.
Obviously got training from the academy.
Yes, sir.
You testified that you saw red eyes
Yes, sir.
and
Object, it's beyond the scope of today's hearing, Your Honor. We're here for the felony. The OWI testimony just establishes the reason why the witness arrived on scene and why the witness was able to, based on the nature of the investigation, identify the witness for purposes of moving forward on the carrying while concealed. We're not here to adjudicate the issue of the OWI this morning.
well, that's not fair, Your Honor, because he got all that testimony out of this witness because he's trying to use the drunk driving as the crime of arrest for a valid inventory search. The cross-examination is allowed because if that was a pretext search, then the fruits of that search should be suppressed under People versus Toohey. And I'm-
I would agree. There was a number of questions posed to this witness on direct regarding the OWI because that was used as the basis, I guess, for the arrest and the search. He got testimony about slurred speech and the conditions, what he smelled, what he looked like, his clothes, a wet spot on his pants, why he didn't do SFST. So I've got to give the defense some leeway. The objections overruled.
Okay, so I think I asked you about red eyes is what we're on, right?
Yes, sir.
Okay. You had never met Kevin Krasinga before that night, I take it?
No,
The red eyes may have been he was crying because he was in a fight with a girlfriend, right?
could be.
You remember discussion about that with him?
I don't recall, sir.
Again, body worn camera, review it.
Okay.
I'm going to
Um,
object to that aspect of questioning under hearsay rule.
As to reviewing the body cam.
No, as to what the statement of the defendant to the officer.
I think the question was, did you talk to Mr. Krasinga about whether he did in a fight with his girlfriend? Which would not be hearsay. I'm not eliciting a statement from any other person. Just asking him to have a conversation.
The statement would be with respect to the what the nature of their conversation was. So we still fall under the hearsay rule.
The objections overruled.
I think you answered it right, Officer Mosley.
And I don't recall.
Okay. And business about you saw what you thought was a stain on his pants. Remember that testimony in direct examination?
Yes, sir.
And you said you smelled it and it smelled like urine.
Yes, sir.
This was after he turned around and walked backward to you with your gun at the low ready, right?
Well, at first he was facing me. You can see that there's a stain there. Then when he turns around, the stain's still there.
Okay, thank you for clarifying that. He had eyes on you and you had eyes on him, right?
Yes, sir.
And you get out of your car and you pull your gun out at the low ready, right?
Yes, sir.
And other patrol units are right behind you, right?
Yes, sir.
Obviously, this could be, say, excitable to any reasonable person. Do you agree with that?
Yes, sir.
The testimony that you gave about slurred speech, I already asked you about never meeting Mr. Krasinga before that night, so you obviously don't know what he sounds like when he's talking with 0 alcohol in his system or 3 beers for 6, right?
I've met him before, sir.
And I think you said something like ja, 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 or something.
Yeah, just a general terms, just general words, how he wasn't quoting anything specific.
For the court reporter's benefit, when she has to transcribe this, can you agree, ja, 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 CHA?
Something like that, I guess.
Okay. Gotta remember, we're making a transcript here.
Yes, sir.
Um, the point about the crime of arrest that you were asked about on record examination. Okay. In between the call out to, what was it, 6545 Mercantile?
6245, something like that.
Thank you, 6245, good memory. 6245 Mercantile Way. For the damaged vehicle, and then later the possible shots fired, right? That there wasn't a whole lot of time between initial call and the call that escalated things, right?
In about 5 minutes, sir.
And how much time before you arrived was the subsequent call about the potential shots fired?
Oh, so the call for the shots fired came out prior to my arrival.
Correct. How much prior is one of them?
Oh, that maybe 3 minutes.
So certainly enough time for all you guys to think about, this is what we gotta do now, is we've got a potential critical incident, right?
Yes, sir.
When you roll up there, you're looking for this truck, right?
Yes, sir.
And you're looking for whoever may have fired a gun, right?
Yes, sir.
That's what you cared about, not the drunk driving, right?
At the time, sir.
And nothing further.
Your Honor, okay.
So it's the excuse.
You may, Your Honor. Your Honor, my next witness, Officer Daniel Foote, he is on his way here. He is a member of the STAR team. He was serving a warrant this morning. It looks like he's about 15 minutes away. May I ask for just a brief recess? There's another exam that we could start while we wait on my witness to arrive. Your Honor.
That's no problem. We can adjourn for 15 minutes.
Thank you, Your Honor.
Does Officer Foote know the prosecutor has a GPS tracker?
Probably not.
Could just be Life 360.
Matt. Good comms with my, witnesses.
Okay, let's see. Donnelly, you have another matter?
That's probably what he's talking about. Yes, we're gonna run Muhammad.
Brian Muhammad, and then Ollie has a P53. Mr. Johnson is, I'm sorry, he just needs to be reading. Okay, and Horton, everybody Horton,
Your Honor, I have not had contact with Ms. Wood.
she's in jail, isn't she? Yes.
Yes.
She's in jail.
She is found out.
She on my jail watch list too? Yes. She's in jail. Downstairs.
Oh, I didn't know that. Oh, okay. All right, you're right.
You long, how many witnesses do we have?
Just the one, Your Honor.
That's how we do that. On the record in the matter of the people of the state of Michigan versus Hamza Muhammad 25-00003, appearance please.
Good morning, Your Honor. Matt Nagel for the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Hamza Muhammad, who is to my right.
Okay, today was the date scheduled for a preliminary examination on police officer assault and resisting. And we're ready to proceed.
We are, Your Honor. Just before we get started, I'd just like to put on the record that an offer has been extended in this matter, that the defendant plead guilty to count 2 domestic violence, and the people would dismiss count 1 resisting obstructing. And it's my understanding that we will be continuing with the preliminary exam because the defendant has turned down that offer.
That's accurate.
Yes, Your Honor. It was also basically threatened that if we didn't want to accept the offer today, that we were running the exam, so, yes.
I would object to the term threatened, but that it was a condition of the offer.
It was a condition of the offer.
Okay, the offer was for him to plead to count 2 and dismiss count 1,
That's correct, John.
and it was conveyed to him when?
We knew about it, the offer at the probable cause conference last week, Your Honor.
Okay, and so the offer expires at the start.
Correct, Your Honor.
It's typical. You understand the offer, sir?
Yeah.
For you to plead to the domestic violence, and they would dismiss the other charge. Okay, you want to give up that offer today?
Yeah.
Okay. You don't need an interpreter, correct?
No.
Okay, sounds, it looks like there was one at the time of the opening. Okay,
Okay, thank you, Your Honor. The people, nothing else for the people.
thank you. Anything else for you?
Nope, ready to go.
Call your witness.
Thank you, Your Honor. People will call Officer Morgan Parrott.
Over here.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. State your first and last name and spell both.
Morgan Parrott, MorganParrott.
See counsel.
Thank you, Your Honor. Officer Parrott, with whom are you currently employed?
The city of Lansing.
And what do you do for the city of Lansing?
Work for the Lansing Police Department
And in what capacity do you work for the Lansing Police Department?
and the Community Services Unit as a community police officer. I work for road patrol.
And is a part of working road patrol to answer dispatch?
Yes,
Were you working in that capacity on January 1st of this year?
yes,
Do you recall being dispatched to a 1929 West Holmes Road in the city of Lansing that day?
yes,
And is that in the county of Ingham?
yes.
Can you explain to the court what the purpose of that dispatch was?
The purpose of the call was for domestic assault that was in progress.
And you did in fact respond to that address?
Yes.
What did you observe when you arrived?
When I arrived on scene, I saw several kids waving their hands outside of apartment 9,
And,
the
then,
upstairs window.
and what did you do in response to that?
So I approached the front door, and I heard yelling back and forth between a male and a female inside.
Okay. Let me back up for just a moment. When you arrived at that address at 1929 West Holmes, what vehicle did you arrive in?
A patrol vehicle.
Is that a marked patrol vehicle?
Yes, it is.
And it says Lansing Police Department on the side?
Yes.
And do you recall how you were dressed that day?
In this uniform.
And this uniform is a standard issue Lansing Police Department uniform?
Yes.
And you have a badge attached to the left side of your vest?
Yes.
Did you knock on the door?
Yes, I did.
And when you knocked on the door, did you announce that you were with the police department?
I'm not sure.
Okay. What happened when you knocked on the door?
The female answered and then the male came out of the front door.
And what did you do at that time?
Talked to him in the parking lot just outside of the door.
Okay. Did you remove him from the apartment?
He walked out to me himself.
Okay. And what did you do with let me back up. Would you recognize that person if you saw him again?
Yes,
Do you see him in the courtroom today?
he's in the courtroom right now.
Can you point to and identify an article of clothing that he's wearing?
He's over here wearing the camouflage coat.
Your Honor, with that record reflect ID,
Any objections, ID?
No, Your Honor.
So noted.
did you identify him by name when you made contact?
I identified, when I spoke with the female, I asked for his name, his information.
And did you get that name?
Yes, I did.
Do you remember what his name was?
Cosmo Mohammed.
And he's the individual you indicated just a moment ago?
That's correct.
When you made contact with Mr. Muhammad, what was the first thing you did?
Asked him if he had any weapons on him, and I patted him down for those weapons.
And why did you do that?
Just standard practice for when I make contact with someone,
And why is it standard practice, do you know?
for my safety and also for his safety.
Once you had patted him down to search for any weapons, well, let me ask, did you find anything on him?
No, the way we pat people down is we have them place their hands behind their back, and pat them down for those weapons to maintain control of their hands.
And did you find any weapons on him?
No,
Once you had confirmed that there were no weapons on him, was this still an open investigation at that time?
yes,
And because it was an open investigation for a domestic case?
yes.
Because it was an open investigation for a domestic case, what did you do with the defendant at that time?
I attempted to place him in handcuffs behind his back at that point
And why were you doing that?
to detain him.
Is that standard practice?
Yes,
Did you inform him that he was being detained?
I did.
And did you inform him why he was being detained?
Or, I don't know exactly what I said at that point.
But did you make it clear that you were still investigating a domestic case at that time?
Yes, I did.
Did he allow you to put him in handcuffs?
No,
What did he do?
he pulled his hands apart from one another.
And the way he was pulling his hands apart, was this just based on how he was moving, or was he trying to fight you putting handcuffs on him?
He was trying to prevent me from placing him in handcuffs.
And could you explain to the court how you know that he was trying to prevent you from putting handcuffs on him?
Yeah, he was using his strength to pull his arms apart from one another, despite my verbal commands.
And I was going to ask you that next. So did you command him to comply?
I did several times.
And what did he do in response to your commands?
Continued to pull his arms apart.
Okay. How many times, if you remember, did it take you to try to get him? into handcuffs?
I don't know how many verbal commands I made, but it was more than 3.
So more than 3 times.
Correct.
And did you have to force his wrists together to finally get him into handcuffs?
Yeah, I actually used a vehicle that was in the parking lot where we were standing. I used that in order to press him against the vehicle so I could maintain control of his wrist at that point.
And is that to allow you some leverage to get control of his hands?
Correct.
Thank you, officer. No further questions at this time.
Morning, Officer Perry.
Good morning.
So you, how long have you been doing road patrol with Lansing Police Department?
About 6.5 years.
All right, and what about before that? What was your, were you still with the, were you always road patrol with Lansing Police Department?
Yes,
Okay.
I always have been. I recently was assigned the Community Services Unit, which is just an extension of road patrol. And that was about 2 years ago.
All right, and then prior to the Lansing Police Department, had you been a police officer before that?
No,
All right, so on that day, you were the first to arrive on scene, correct?
yes,
All right, and you didn't have another officer with you in your vehicle, correct?
No.
All right, and you had your body worn camera on and working that day?
yes,
All right, and you would recognize your body worn camera if you saw it?
yes.
All right, Your Honor, I'd like to put forth the Officer Perry's body worn camera.
Are you gonna need?
Do I zoom still?
Yes.
Okay, I'll join.
Because I don't think that cord ever works.
I got it downloaded, so it should be a little easier to see.
Can I just ask if this is going to be offered as an exhibit?
Yes.
Defense exhibit Okay.
All right, Officer Parrott, you recognize this as your body worn camera, correct?
I believe so.
All right, and I'm just gonna start from the beginning here. It seems like it started, well, let me ask you this, just to put on the record, clarify, I think we all understand, but when you turn on your body worn camera, there's 30 seconds of video without audio prior to that, right?
That's correct.
All right, so because that we're not gonna hear any audio right now, right? Okay, so I'm gonna start.
There's no audio, correct? Did you put your,
Maybe for word battery in it. Police, come out. Have a seat for me, please. Have a seat for me, please.
It's wet over here. I'm on the phone.
Ma'am,
Can
shut the
I
door
sit
for a
in
minute.
here?
Here, have a seat here.
I can sit on the car. It's wet.
Okay, stand right there then.
Yeah, I can stand over here.
No, I'm good now. I have them out here. Do you have any weapons on you that I need to know about? Can I check?
Yeah.
Okay. Turn around for me. Place your hands back here. I'm not putting you in handcuffs right now. This is how I check to make sure you don't have any weapons. Nothing that's going to poke me?
No.
All right, I'm going to put you in handcuffs for now. Can I have you interlace your hands until we figure out what's going on?
I mean, we can figure that out by talking. Right?
Interlace your hands.
Why am I being on handcuffs for? Hello?
Interlace your hands.
No. Don't look for trouble with me, please. Just tell me what am I being on handcuffs for. Hello?
Send me priority, please.
No.
83.
What is... Can I handcuffs?
Interlace your hands.
No, I need to know whatever. Don't try to be myself with me, man. I'm not here. This is for...
Interlace your hands.
Let's not trouble you like this.
Interlace your hands.
No, I'm asking you why you doing this for. That's what I'm asking. It's simple question. Just tell me what you doing this for.
For my safety and for your safety.
Am I dangerous?
So right now you are being detained.
For what?
You will get another charge.
No, detain me for what?
You will get another charge.
Okay, what are you detaining? No, don't be tough with me. You cannot, don't be tough with me.
You're going to get another charge.
For what?
Interlace your hands. Do as I'm asking you.
You're not answering my question.
Interlace your hands.
My hands is behind you. You have my hands. I'm just talking with my mouth. What am I being detained for? Are you answering my question? One line, you guys are looking for trouble. Okay, look. Don't be hard though. I'm just looking for You think you that tough though?
83, you can slow it down. I have him detained.
He's not good yet.
Yeah, I am. I still need to make sure you don't have anything on you.
You
Now you're
made
gonna-
sure that
Now you're
already.
now you're gonna have another charge.
No, I cannot. For what? Your camera's on, right?
Sure is.
You okay? Good.
I
That's
asked you.
it. Your camera.
place your hands behind your back.
No, I
You
did,
weren't
right?
listening.
I did, right?
Nope.
I didn't.
Nope.
How did you get to me? How did you get to me? No, be easy with me. Hello.
We're gonna walk to my car.
Okay, you walking. Tell me to walk.
Do as I say.
You didn't tell me to walk though.
I am. I told you to walk.
This is my house. Okay, you making me look like a criminal. I'm not a criminal.
I told you to walk.
No, you
You weren't listening.
Tell me let's walk. Leave me alone. I can walk. I'm walking. Leave me alone.
Then walk. Why are you shifting your body backwards to
You're
prevent?
pushing me.
I'm asking you to walk.
You walk. I can walk, man. Just let's walk. Okay. What is
Stop it here, because obviously this is going beyond what the basis of the direct was, but that's all accurate, and that's what happened, right?
Yes.
All right, so it is observed on the body worn camera that, again, like you testified on direct, Mr. Muhammad comes out directly after you knock on the door and it's opened by his wife, correct? All right, and then he comes out and you order him to sit on the wet ground, correct?
Correct.
But then he's like, well, you compromise and you let him stand next to his car and you pat him down. It's observed, sorry, and you pat him down, correct?
Correct.
And then it's observed on the body worn camera that he is asking why he is being detained, why are you handcuffing him, and you say that it's for your safety.
That's one of the reasons.
Okay, well, it was on direct that one of the questions on direct was, did you tell him why you were handcuffing him? And it was your testimony that you were handcuffing him for an investigation, correct? Okay.
Is that a yes?
Yeah, sorry.
Is that at any point in what we just saw, did you tell him that you were detaining him for an investigation of a domestic violence or an investigation?
I didn't specify that it was for domestic violence.
Okay. And then it's per your procedure that when you pat them down, you have their hands behind their back, correct?
Yes.
And he had his hands behind his back while you were patting him down, correct?
During the pat down, yes.
Yes. So would it be safe to say that he became less cooperative when you went to handcuff him?
Correct.
All right. And how many times have you, in the 6.5 years, how many times have you detained for an investigation by handcuffing somebody?
I don't even know how to put a number on that.
It would be safe to say that it would be countless times that you have detained someone and handcuffed them for an investigation, correct?
Yes.
And so out of those countless times, there have been times, obviously, that you have come across people who naturally tense up when you go to handcuff them. Or how many times do people actually like physically tense up when you go to handcuff them?
There would be no way for me to put a number on that.
But you would say it's common that happens as well?
I don't know. Again, I don't know how to answer what's, what's common and what
in your
is not.
training and experience, you can't really estimate just like not a number, but is it rare? Is it unusual? Is it common? Would you be able to specify that type of how often this types of things happen?
There's so many.
There's no objection. Well, she said she didn't know how to answer it, so she's trying to rephrase it. Objections overruled.
What I'm saying is there would be no way for me to evaluate that number, and it's all circumstantial depending on what I'm there for, what someone's being detained for. There's so many factors. I wouldn't be able to accurately depict that.
Let me get some clarification. Question is from you is it common or uncommon for people to tense up when they're being arrested?
Or, you just, yes, tense up, or if not that wording, but in general, these types of behaviors and actions, how often does she see them?
Okay, how long have you been an officer?
6.5 years.
Okay, so you've done a lot of arrests.
Yes.
Think you can answer, is it common or uncommon to experience someone tensing up when they're being arrested. I don't think it has anything to do with the type of arrest. You can answer that question.
Honestly, I don't think I can.
You never
And
experienced
so I
anyone
can-
tensing up
So I have, yes, but that wasn't the question that was asked to me.
more than one time?
Yes, I have experienced it more than
She
one
asked,
time.
was it common or uncommon? Just like if I were to ask you a question about you investigating in a drunk driving case, and I asked you, was it common or uncommon for there to be slurred speech?
I'm gonna answer yes to that.
Then you should be able to quantify it. So now I'm asking the number of times that you've done an arrest. Is it common or uncommon for individuals that you've arrested to tense up when you're placing them in cuffs?
I've had it happen before. Does that answer the question? I have had it happen before.
We understand that, but that may still mean, the answer still could be that it's rare just because it happened once. I'm trying to understand how often would you experience something like that?
Again, we're asking me to quantify something that.
No, I'm not actually to give a number. Just like I wouldn't
Yes,
actually,
it has happened before.
okay.
To say that it's common or uncommon or
About how
rare.
many times have you arrested someone or taken them into custody?
Again, are we supposed to go for a number? I'm sorry, I'm just,
You can tell me it's in hundreds, but it's a common question we ask
it
officers.
perhaps can be hundreds.
Okay, and so you've done hundreds of arrests.
I've done
in 6
hundreds of
years.
arrests.
That's reasonable, right? Okay, and so do you think that it's been about half of that people tense up?
Probably less than half. I
Probably
would
less
say.
than half. So it's not uncommon, but it's not like something that you see every time you arrest.
Correct.
Okay, does that help you?
Yes, that does. Thank you, Your Honor. All right, and so, and then, your testimony here today was that, so per the body worn camera, you can clearly hear Mr. Mohammed asking, over and over again, why was he being handcuffed?
Yes,
All right, that's pretty much the predominant question he was asking, correct?
yes,
Okay. And you were, and it's per your body worn camera in your testimony, that you were able to get him handcuffed without any other officers or assistants, except for, but you said that you had him on the car helped you?
correct.
Okay. So was he ever able to, did he ever take his hands out of your grip?
I believe I was able to maintain control of his wrists.
All right. And so, and then, and like you said, you were able to then get him to what it looked like you were pushing him towards your patrol car.
Yes.
Okay. All right. One more thing. So obviously, after 6.5 years, when you are dispatched to an incident, you are preparing yourself for what you're going to see, correct? You, as per your training and experience, you mentally prepare yourself for arriving on scene for your job
Yes.
in a way that you you were dispatched to an active domestic violence situation, correct?
Yes.
All right, so you, in your mind, you know what to expect when you arrive or what to look for, correct? Like you have certain,
The
you're
dispatch
obviously,
information is that there was a domestic assault in progress. And then they were giving us information over the radio about things the call taker was hearing.
okay, so when you,
So it's an evolving.
Okay, so it's even an evolving situation, so you have to be prepared when you arrive for an evolving situation.
Yes.
All right, and so per your training experience, you tend to make sure that you leave yourself, making sure that you have like your head on a swivel. You have to make sure that you have to make sure that there's no one behind you, or, especially when you're by yourself, correct? There's extra heightened senses that you are using. Or say,
Yes.
like your awareness, especially when you're by yourself, it's heightened. Would you say that, or would you say that your experience is the same whether you're with someone or not?
No, the experience isn't the same.
This experience is different, so, all right. All right, you're not no further questions.
Okay, I just need you to play the body cam portion again.
Am I still sharing?
I think I stopped it when they.
That's why I didn't want to
Oh.
stop sharing in case you want to see it again, but that's fine.
I just didn't know if there was an alarm or something on your computer, that's why.
Yeah, that was my jabber. There was a phone call coming in.
Nah.
Okay, so I'm sharing it again. I'll go back to the beginning. Playing from the beginning.
The audio doesn't start yet, is that what it is?
Yeah, this is
Oh,
the,
okay.
where's 20 seconds?
Maybe 3 words matter, you know. Police, come out. Have a seat for me, please. Have a seat for me, please.
It's wet over here. I'm on the phone.
Ma'am,
Can
shut the
I
door
sit
for a
in
minute.
here?
Here, have a seat here.
I can sit on the car. It's wet.
Okay, stand right there then.
Yeah, I can stand over here.
No, I'm good now. I have them out here. Do you have any weapons on you that I need to know about? Can I check?
Yeah.
Okay. Turn around for me. I place your hands back here. I'm not putting you in handcuffs right now. This is how I check to make sure you don't have any weapons. Nothing that's gonna poke me? All right, I'm gonna put you in handcuffs for now. Can I have you interlace your hands until we figure out what's going on?
I mean, we can figure that out by talking. Right?
Interlace your hands.
Why am I being on handcuffs for? Hello?
Interlace your hands.
No, don't look for trouble with me, please. Just tell me what am I being on handcuffs for? Hello?
Sound me a priority, please.
No.
What are you asking me? You saying unrelease your hands? Is that what you're saying?
I'm saying interlace your hands.
Interlace?
Interlace them, put them together.
Okay. You can continue.
No. Why you?
Interlace your hands.
No, I need to know whatever. Don't try to do herself with me, man. I'm not just here. This is crazy.
Interlace your hands.
Let's not start the year.
Interlace your hands.
No, I'm asking you why you doing this for. That's what I'm asking. It's simple question. Just tell me what you doing this for.
For my safety and for your safety.
Am I danger to
So
you?
right now you are being detained.
For what?
You will get another charge.
No, detain me for what?
You will get another charge.
Okay, what are you detaining? No, don't be tough with me. You cannot, don't be tough with me.
You're gonna get another charge.
For what?
Interlace your hands. Do as I'm asking you.
Answer my question.
Interlace your hands.
My hands is behind you. You have my hands. I'm just talking with my mouth.
I'm sorry, Your Honor.
Okay, can you go back a couple of seconds? Because I'm trying to figure out when the camera turned, if I can have the witness explain what was going on there.
going back, let's see, Richard. It's about 15 seconds.
Hey, what are you doing? No, don't be tough with me. You cannot, don't be tough with me.
You're gonna get another charge.
For what?
Interlace your hands, do as I'm asking you.
You're not answering my question.
Right there. What's happening right there?
He is actively moving his arms into the front of his body.
Okay, so is that what caused your body to shift so that we can't see the camera?
That's correct.
Okay.
So my camera's here, so if I'm trying to maintain his hands, sometimes it will be, you'll get my arm, which is right
Oh.
here.
Just for the record, the officer indicated the right side of her body.
Right side of the body, right around the chest area?
That's correct.
Okay. You can continue.
Interlace your hands.
My hands is behind you. You have my hands. I'm just talking with my mouth. What am I being detained for? Are you answering my question? Yeah. Wallahi, you guys are looking for trouble. Okay, here. Don't be hard though. I'm just looking for You think you that tough though?
Thank you. Redirect.
Oh, thank you, Your Honor. Officer, just a few questions for you. There was some questions on cross as to whether or not it was common for people to tense up or pull away from you as you're trying to put them into handcuffs. Do you remember that line of questioning?
Yes,
And I know you said that you were having trouble, say, quantifying it, but I think your testimony is that it is your experience that that has happened before.
it has happened.
And in your experience, when that has happened, is it common for you in those circumstances to seek charges for resisting and obstructing a police officer?
Yes,
In the video, we see that when the defendant first came out of the building, you had indicated that he should take a seat at the foot of the stairs, correct?
yes,
And did he comply with that command?
no,
But you were gracious enough to allow him to move over to another location, correct?
yes,
And then you did indicate to him that you were going to search him and he did comply with that command. Would you agree?
yes,
When you told him that you were going to put him into handcuffs, it's at that point that, would you agree that his demeanor became argumentative with you?
yes,
And I know you indicated on cross-exam that you did not say that you were detaining him as part of an investigation, but do you recall seeing in the video that when he said, "Why are you putting me in handcuffs?" you responded, "Because we're trying to find out what's going on." Did you see that part?
yes,
And he continued to pull away from you and argue with you, correct?
yes,
And when he continued to pull away and argue with you and he continued to ask you, "Why are you doing this?" correct?
yes,
Even though you had previously informed him, "Because we're trying to find out what's going on."
yes,
But then you answered him again, saying that this is for your safety and for my safety. Do you remember hearing that?
yes,
And after all of that, he was still pulling away from you, correct?
correct,
And then the court inquired of you, because we could not see what was going on for a brief period of time, what was happening in that moment, and you indicated that it was because he had pulled his hands out to the front of him, correct?
correct,
In order to do that, he had to pull his hands away from how you were trying to control him behind his back, correct?
that's correct.
Thank you. No further questions, ma'am.
Thank you. Is for this be excused?
Yes, Your Honor, thank you.
Thank you, officer.
Thank you.
Any additional witnesses?
Not for the people, Your Honor.
Okay, any witnesses from the defense?
No, Your Honor.
Argument. Argument?
Oh, thank you. I didn't hear you. I apologize, Your Honor. Your Honor, the people would be requesting bind over as charged. In the first count, resisting and obstructing, the people have the responsibility first to prove that the defendant did assault, batter, wound, resist, obstruct, or oppose or endanger the police officer. In this case, Officer Morgan Parrott. The testimony and the video establishes that while the officer was trying to detain the defendant, put him in handcuffs while they looked into this domestic complaint, that the defendant argued, tensed up, pulled his hands away at one point, pulled his hands from behind his back into the front of his body, actively obstructing and opposing the officer. Second, that the defendant knew or had reason to know that when Officer Morgan was performing her duties, that she was doing so in an official capacity. In this case, the officer arrived in a marked Lansing police vehicle. The officer was wearing Lansing Police Department clothes. The defendant was compliant at first when the officer went to search him for any weapons for her safety. So the record is clear that the defendant knew that the officer was an officer with Lansing Police Department and was acting in her capacity as such. And then third, that the defendant gave a lawful command. In this case, the testimony was that while this was a domestic call out, that it is common for the officer to detain the individuals while they determine what is going on. This is common practice. And as the officer explained to the defendant at the time, that it is for both the officer's safety and the defendant's safety as well. And then fourth, that the defendant's actions were intended by the defendant, and that is not accidental. In this case, the testimony established that the defendant had argued with the officer, even though the officer had answered his question several times as to why he was being put into handcuffs. The defendant continued to argue, and then, as was clear from the video, actively moved away from the officer, and at one point pulling his hands back from behind his back to the front of his body, clearly indicating that the actions by the defendant were intentional. Based on the evidence presented in the testimony offered, we would ask that this matter be found over on count 1 and count 2, the domestic violence, to send up alongside the count 1, the R&O felony. Thank you, Your Honor.
Thank you, Your Honor. So I would like to characterize some of the evidence that the prosecutor thinks goes to their side. I think he's ignoring some of the evidence that was presented also today, especially when it comes to the pivotal part in the body worn camera where we lose sight of what's really happening. And it's our understanding from Officer Parrott here today that the defendant was moving his hands to be in front of him, but she also testified on cross that at no point did she lose control of Mr. Muhammad's hands, of his wrists. So the testimony clearly shows that he had tensed up, he was confused. I think that when we look at the elements, the main one here is, what did he knowingly and willingly fail to obey? He was given, yes, you can see on the command, he was given multiple commands. He was given command to sit down on the wet floor at first. He was given a command to put his hands behind his back, which he followed. But what happened was, according to the body worn camera to Mr. Muhammad, was he was being asked to be pat down just to make sure he didn't have any weapons. And then it escalated in a moment to, I'm handcuffing you. And despite what prosecutor says that she did not say multiple times why she was detaining him, he asked multiple times why he was being handcuffed. She says once, we're gonna figure this out. 2, it's for your safety. That's basically it. He was given no other explanation. Basically, the issue I have with this case is whether he was provoked into what looked like an attempt to resist. I don't even think I would ask this court not to bind over on the resisting, only because if she was able to get him handcuffed by herself without any assistance, and she never lost control of his hands, then if anything, this was an attempt at a failure to obey. But again, the element that I would like the court to consider is whether he knowingly and willingly failed to obey a command, because obviously, given the situation, I would argue that it's almost natural instinct when given what he was about to be handcuffed in, that he would tense up and want to know why he was being arrested. And when he wasn't getting any sort of real answer, the real answer was, I am arresting you because there's allegations that
For detaining you.
You're detaining you for an investigation of over some sort of assault where we've been called because, and we're detaining you for that. That was not anything, and not obviously nothing that the officer, I'm not arguing the officer was required by law to tell him that, but I think that it goes to the element of whether he intended to fail to obey the lawful orders. I think that he was put in a situation where he was being almost provoked to do something, but obviously.
Clarify for me what you're believing was the provocation for the or what you are terming as a slave driven. What exactly would that be?
So again, not trying to say that the officer was required to tell Mr. Mohammed why she was detaining him and handcuffing him, but by the way that she was interacting him, saying, I'm just going to pat you down. Please just put your hands, I'm just going to pat you down. And then in a moment, in an instant, it becomes, here are the handcuffs, you're being handcuffed. I think that without any sort of explanation, it would be very natural for Mr. Mohammed to react to that, react negatively to that. In that way, that's why I went in that line of questioning about tensing up. I believe that it is not unusual for people in that circumstance to their natural reaction, something they can't control, something that is not knowingly and willfully being done, that they would tense up like that, and maybe even pull and pull away a little bit. But again, for all this evidence, it doesn't seem like that was successful. And it doesn't seem like it seems like what we got here is a charge stemming from basically there was a threat. If you didn't completely cooperate right now, you were going to get charged. And when he didn't, that's why we're here. So, Your Honor, I would ask that.
But that's how it works, though. She's telling him, interlace your hands about 10 times. And then she's saying, if you don't listen to my command, then you'll get another charge. She's warning him. And then he still doesn't listen. So then he gets the charge.
Your Honor, again, that's not where I don't believe I'm arguing against any other element. She was an officer in a full uniform. He had reason to know that she was an officer. He had reason to know that they were all lawful commands. But the element is that did he willingly and knowingly fail to obey a command? And my argument is that by all this evidence and the interaction that happened, he didn't. And that if anything, it was merely an attempt. And then we ask this court not bind over. Thank you.
Thank you. You're also. Okay, today was the date that was set for a preliminary examination. The burden is on the prosecution and they need to put forth sufficient probable cause that the felony that's been charged was committed, and then sufficient probable cause to charge you with the felony. This is not a trial. This is not the time where they need to prove each element beyond a reasonable doubt. They only need to establish more than mere suspicion that the felony occurred. And then the court will weigh the credibility of the witness and assess the likelihood of the state's success at the time of trial. You've been charged here with one felony, police officer assault, resist obstructing. Mr. Nagel has already gone over the elements. The testimony was from Officer Morgan Parat, I believe is how it's pronounced. She testified that on or about January 1st, 2025, she reported to the area of 1929 West Holmes Road, City of Lansing, Ingham County, State of Michigan, which makes venue appropriate in this court. She identified the defendant in the court as the suspect that she made contact with when she arrived to the scene. So she arrived and saw several kids waving their hands and heard a male and female inside the unit yelling back and forth between each other. She identified herself to be in fully marked uniform and driving in a fully marked police LPD patrol vehicle. She said that she asked the defendant to come outside. She performed a pat down search for safety, and that she gave the defendant multiple commands, and that the defendant pulled his arms apart. More than 3 times she testified that there were commands given for the defendant. to comply with her order, and that she ended up having to use a vehicle to press up or press the defendant's body against her vehicle to maintain control. On cross-examination, defense exhibit A was admitted, which is Officer Brock's body worn camera. The court made questions during cross-examination about the frequency or the normalness of tensing up during an arrest. I think that even though the officer wasn't comfortable with quantifying how many times, I think it's normal that some people may tense their bodies when they're pulling their arms behind their back and having to go in handcuffs. Because we have to understand, obviously, officers don't have a clue what this person could have a torn rotator cuff. We don't know what's going on. They could just be scared. A number of things could cause someone to tense up when they're being placed in cuffs. I believe that that's normal. I agree with you, Ms. Donnelly, as it relates to it being likely that someone could tense up during the time that they're being arrested. I think that the concern that the court has that creates a question of fact is the area on the body cam that the court had you pause and question the witness about specifically. And that area was where you can see just prior to that, where Officer Barat had questioned, or I should say, she had ordered Mr. Muhammad multiple times to what she had asked her what she was saying, interlace your hands. I don't know if it was a body cam issue or if it was just the words or the terminology or maybe an accent that she has. I thought she was saying unrelease your hands when I was listening to the video. That's why I asked her, what are you saying there? She's saying interlace your hands. Interlace your hands, I think, to me, could be pretty clear. Mr. Muhammad needed a Somali interpreter at the time of a arraignment. I don't know if he understood what that means. I also agree, Ms. Donnelly, with your assessment as to the communication with the officer. I believe that the officer, although no duty requires her to, could have done a better job of explaining, I am detaining you while I do this investigation, because he's asking the multiple questions. Well, why? Well, why? The concern or the issue is it's not a requirement for her to tell him. He told him, however, about 10 times to interlace your hands. And in the portion where we don't see, we can see pretty much what's going on the entirety of the video until her body cam turns and there's a view that we can't see. And I question her about that because what I assumed was what she said in her response was that he pulled his hands now in front of his body, and that caused her to shift. Whether the officer is willing or at this time explaining to you the reason for the detention does not give you an excuse to not follow the command. She said that it was for your safety and for her safety. That is the reason. And so for you, which we can see, it wasn't questioned, but the stature between you and this officer is not the same. And she's trying to put you in handcuffs and you turn your body, well, then you shift her body. And so she's already giving you, prior to this happening, multiple commands to put your hands behind your back and to interlace your hands. It's different if he had said, I don't know what you mean by that. That's not what happened. There was a shift in your body, which caused a shift in her body. And then she then had to use the vehicle there to leverage to bring the cuffs, bring you into custody using the cuffs. And so I believe that there's sufficient probable cause based on that portion to bind over on count 1, police officer assault, resisting, obstructing. Count 2 of domestic violence is a misdemeanor. We don't address probable cause for that. That will accompany the felony charge to the circuit court. Your bind over date is going to be January 29th. That's the date the circuit court's going to get the file from the circuit court's going to get the file from the district court. I don't see where this is actually signed by the judge. You, however, do not have to appear in the circuit court on the 29th. Do you understand that? The next court date will be a pretrial in circuit court. Your attorney will be made aware of that date. What's your address? Where are you living?
Right now, I don't know his address. I'm at my cousin's house. St. John's, I don't remember what number.
St. John's or St.
St.
Joseph?
Joseph's.
St. Joseph's, okay. What's your phone number?
817-988-0429.
Bond was set at 500 personal recognizance will continue. Any additional matters for the record?
No, Your Honor, thank you very much.
Your Honor, yes, I do want to address bond. Mr. Mohammed is is a trucker, and he's an interstate trucker, and he wants permission to leave the state for work.
When did he become an interstate trucker?
I've been driving for 10.
At the time of his arraignment, less than 2 weeks ago, he said he wasn't working.
Yes, currently I'm not working, but I'm looking for a job. But I was just waiting for this court date. And then
So you're not an interstate trucker then?
I am over the road trucker. That's what I do.
Are you do you have a job or not, sir?
Currently, no.
So why are we addressing bond about a job that you don't have?
The job is waiting for me. Like if
What do you
I call
mean?
them right now and say I'm ready to go, they're ready to give me a job.
You've been offered a job?
Yes.
Where?
Out of Chicago, the company in Chicago.
What's the name of the company?
I don't remember the name.
You've been offered a job of a company in Chicago, you don't know the name. Bond motion is denied. You can address it at the circuit court when you get more information. Thank you.
I'll let you know when this court date is.
On Kuzinga, and then it sounds like Horton is going to be a waiver. Be ready to proceed with whichever case the court wants to start next.
Well, we've already started. Presenting, so we have one more witness,
We do, and we're ready. Now.
and Horton's in custody, so she's gotta be brought up, so we'll do that after.
Sounds good. We just taking advantage of the time, we want to do the signatures on the waiver while we're waiting for while we're doing everything else.
Your officer's here,
Yes, he's here. Yes.
back on the record. You can call your next witness.
Thank you, Your Honor. Yeah, people will call Daniel Foote.
While he's getting his witness, I've shown Mr. Foote the salient parts of his body on camera that I want to show during this proceeding. Gave him his police report that we didn't have, so he could review it. He's the one who found this gun. That's the CCW basis. I'm gonna object to the gun because the search was improper. This will do testimony, yes, but just so the court knows.
Okay, thank you.
Mr. Bolton is prepared to play the video because he's younger than me.
That's Horton's phone. Waiver, so the attorney's back there, they gotta sign paper. You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can have a seat. State your first and last name and spell both.
Daniel Foote, Daniel, Foote, Foote.
See.
Thank you, Your Honor. Officer Foote, with whom are you currently employed?
Lansing Police Department,
And what do you do for Lansing Police Department?
patrol officer.
And what are some of your duties as a patrol officer?
Take calls for surveys, conduct traffic.
Were you working in that capacity on the night of September 11th, 2024?
Yes,
Do you recall being dispatched to a location on Mercantile Way in the city of Lansing?
yes.
What was the purpose of that call?
I was dispatched to a weapons complaint. The caller advised that there's a male with a firearm in that vicinity. Later, the caller advised that the male was actively shooting at them.
And did you respond to that location?
Yes,
What did you see when you arrived?
I saw a truck parked in the middle of the roadway. Officers got out, a male got out as well. And giving commands to the driver of that vehicle.
Were you the first officer on scene?
I was not.
So when you arrived, there was already an officer there. And I think you testified that there was another person there. Was that person identified when you arrived?
Not that I remember.
Where was that person located when you arrived?
Outside of the vehicle on the driver's side.
And could you tell whether or not the door to that vehicle was open or closed?
From the angle where I was saying that.
I think you testified that part of the reason for the dispatch was that there was an active weapons complaint.
Yes,
And part of the call out was that there were shots fired. Is that what you testified about?
yes.
So what does that mean to you, hearing that information and responding to this scene? What are some of the precautions that you would take?
So there's a firearm involved, so it's a very serious call to us. So obviously when I got there, I got out of my patrol car and unholstered my duty weapon. And conducted a felony stop on the vehicle.
Can I stop you there?
Yes.
So when you say felony stop, what does that mean?
It's a type of stop in a high risk situation where there's possibly a weapon involved. It's just from a tactical standpoint, provides us better coverage. And we're in a safer location outside of the vehicle with the cover.
So what's your primary concern then when you're conducting a felony stop? What's your primary concern in that?
Our safety and other subjects' safety.
So when you arrived, you saw this individual outside of a truck and there was one other officer present. That's what you testified about?
Mhm.
Did you know, could you tell
Is that a
from where you,
yes?
is that a yes?
Yes, sorry.
Could you tell from where you were located when you arrived, whether or not there was anybody else in the vehicle?
I cannot.
And when you arrived, did you arrive at the front of the vehicle, behind the vehicle, at the side of the vehicle? Do you remember what your aspect of the vehicle was?
I was on the passenger side of the vehicle.
And what time of day was this?
Nighttime.
Was it a well-lit area?
I would say not really.
So from your perspective, at night, on the passenger side of the vehicle, could you see into the truck?
A little bit, but not completely.
And you said you were on the passenger side?
Yes,
Was the door open or closed?
close.
Was there, I know some pickup trucks have an extended cab and there's a back door. Was this a vehicle that was like that?
Yes,
Was the back door open or closed?
that was also close.
So at this point, you know there's one other person, there's potentially a gun involved, and you don't know if there's anybody in the truck.
Need to object to the form of the question. I don't think the testimony was that there was indeed one other person. I think the testimony was that they did not know whether there was any else subject. So that assumes facts, not evidence.
Actually, I was setting a foundation for a follow-on question, and that was precisely it. There was nobody other than the defendant present that you knew of, correct?
So you're withdrawing your question, and you're rephrasing. That's what it sounds like.
I guess I am, I didn't realize I had to rephrase it. That was the question I thought. I
Well,
was
we have to
asking.
address the objection, and you just asked another question instead of addressing the objection.
I
So
will-
I'm gonna take that as a withdrawal of the question and re-asking it.
I believe the court entirely. I think that was the question I intended to ask, so I'll. Does that accurately describe what you observed at that time?
Yeah,
So because there's potentially a gun involved and it's unknown whether or not anybody else is present during this felony stop, what do you do about the truck?
after we detain the one subject, that we believe is the only subject there, it is then our job to clear the vehicle and make sure there's no one else in the side of the vehicle.
And why do you do that?
For our safety, and the public safety.
So when you clear the vehicle to ensure there's nobody in there, is that a search?
No, we're just strictly making sure no one else is in the vehicle.
When you looked in the vehicle to determine whether or not there was anybody present, did you see anything that stuck out to you that was relevant to your call out?
Yes,
What did you observe?
I observed a black handgun on the front passenger seat.
There's an objection.
My objection is, as I indicated before the witness came in, there's no constitutional valid theory for this search. Haven't heard one talking about clearing the vehicle. That is, but I initially thought this was going to be an inventory search argument, but apparently it's not. But that's my objection.
Well, as the testimony opens up, Your Honor, we're getting to something that's in plain view, which there is a constitutional basis for.
Okay. There's a constitutional basis for plain view, but he just said it was clearing the vehicle, which means he entered the vehicle to see if there's anyone in there.
Well, I can ask about that.
Thank you.
So when you testified that you cleared the vehicle, did you have to enter the vehicle?
I did not specifically enter the vehicle, we just opened the doors to the vehicle to make sure no one was hiding.
And was that necessary in order to ensure there was nobody else in the vehicle?
Yes,
And when you opened the vehicle door, did you see anything in plain view?
yes,
Officer, may I approach?
yes.
Your Honor, may I approach?
You may.
And I both have one. Sorry. I'm showing you what's been marked as People's Proposed Exhibit 1. Do you recognize that?
Yes,
Can you tell the court what that is a photo of?
Can I see the proposed exhibit? Two.
I'm sorry, Officer, can you explain to the court what that is a photo of?
It is a photo of a firearm located on the passenger seat of that vehicle on top of a yellow Coors beer box.
And do you recognize that photo?
Yes,
Is that an accurate, is that a clear and accurate representation of how that vehicle looked to you on the night of September 11th, 2024?
yes.
Your Honor, the people move to have People's Proposed Exhibit 1 admitted for the record.
Any objection?
Wadir,
Yes.
have in my hand what's been marked as plaintiff's proposed exhibit number 1. I take it you took this picture?
Yes.
Because you and I both looked at your body worn camera and we can see you using your phone, taking pictures inside the interior of the vehicle. That's how you know.
Yes.
The items that are depicted on this vehicle are on which part of the truck?
Like are you saying driver's side, passenger side?
Correct.
Passenger side.
Front
seat.
Front or back?
Front seat.
You recall the windows were tinted?
I do.
No further voir dire and no objection.
Published to the court, Your Honor.
Yes. That's a minute.
Just in the course of your investigation, did you check the registration on that vehicle?
I did not personally do that.
Um, Did you check whether or not the gun was registered to anybody?
Yes, I did.
And did you determine to whom that firearm was registered?
Yes.
I have a standing objection on the gun, or do I need to?
The objection was as to the search. Is what my understanding was?
Yes, and what the fruit of the search was, which is this gun that's been
Okay.
described.
The objection's overruled. He said he didn't search the vehicle. He opened the door. He didn't enter the vehicle, that is, and it was in plain view.
Thank you, Your Honor. And I'm sorry, could you tell me, could you explain to the court to whom this weapon was registered?
Mr. Kristen.
And were you able to determine that night who that person that was present when you arrived was?
When I arrived, I did not know what that subject was. Later in the investigation, I found out that that subject was in fact Mr. Kristen.
Did you see anybody else present that night at that location?
No.
Let me rephrase, I apologize. Did you see anybody other than law enforcement present in that location?
No.
And I know you said that there was nobody else in the vehicle when you opened it, but did you see anybody else who took responsibility for that vehicle? Did anybody come and say that they were with Mr. Kristen?
I object to that. Calls for your set.
Objection sustained.
Did you find anybody else who was in that vehicle that night?
No.
Officer, thank you very much. No further questions, John.
Cross-examination.
You have training as a police officer.
Yes, sir.
You are on the START team, I understand.
Yes, sir.
Were you on the START team on September 11th, 2018?
Objection.
I'm sorry, 2018 is when you started,
What
2024.
was the objection?
It was going to be relevance, but I think. Counsel
I had the
just
wrong
clarified.
date.
Oh,
It's two-
okay.
September 11th, 2024 is the night we're dealing.
Sounds good.
Yes.
There is specific training about clearing a scene where there might be other people, correct?
Yes.
That includes other people in a vehicle, like in this case.
Yes.
Just got to make sure that there is nobody else inside an area, whether it's a garbage disposal, or a dumpster, or a truck, or a vehicle of any kind, right?
Yes.
You got to just make sure there's nobody there who could hurt you, right?
Yes.
And to do that, what's your training?
In regards to the search.
Well,
Or-
don't you start with verbal force or verbal commands? Hey, is there anybody in there? Identify yourself, police, things like that.
Yes, sir.
Do that. I think it's your voice we hear yelling at one of the other officers, Moshi. Back up or stay there or something like that.
Yes.
You were a person and you were trying to make sure he didn't get in the way of what was going on with the subject, and I think it was officer Mosby, right? Yes. You reviewed your body worn camera before you testified, right?
Yes.
It's a fair and accurate representation of what your observations were as captured by your WC or body worn.
Yes.
I received it electronically, not on any sort of a disk or drive. So I got nothing to mark, but I'd like to admit it, play about 2 minutes of it as defense exhibit.
The objection.
Oh, yeah. Mr. Boltman, my clerk, could plug into the TV or. I
If
can-
that works, because sometimes it doesn't sync in here, I don't know why, otherwise you have to get into Zoom and then I'll just make you co-host.
Okay.
I think he's. You should just go into the Zoom, it's easier, because that's never worked in here.
Okay.
You'll get it Zoom ID. It has to be called.
Okay, so I can't see the running time, but I think we were queuing it up to about 5 minutes, 20 seconds running time. Exhibit A. Go ahead, Mr. Bolton.
Did you do share sound on that when you shared screen? Cause I hear it coming from your computer, not the. I think if you exit share screen and start it over and click share sound. When you click share screen.
She's on the runway. Moshi, watch out. Moshi, stay there.
With me?
Yep. We're clearing. Stay clear over there.
I got that. Pretty
All right. Open intox over here too.
clear.
You want the tailgate or 37? We got one detained.
Can't get right on down towards like
Is it unlocked?
Yeah.
You're good.
I think we can pause it. Can't see the running time.
6:42.
Thanks, Your Honor. 5:20 to 6:42. What we just played. So, officer, that black object is, your independent recollection is the gun that you retrieved, right?
Yes.
And that you checked the serial number and it came back to Mr. Kristen, right?
Yes.
Your independent recollection was not, you didn't have one about whether the windows were tinted, but based on looking at Exhibit A, does that refresh your recollection?
Yeah, that was not focused on the windows there.
No problem. The other issues that I wanted to ask you about are LPD or Lansing Police Department policy on clearing vehicles in a scenario like that, a felony stop, critical incident. What's the policy if you?
I don't know it off the top of my head.
Okay. How about general police officer training?
You call for the subject to walk back to you. Once you have that subject detained, you allow for other occupants of the vehicle. If there aren't. So if there aren't, you just call.
Pause right. Okay. Okay. I was confused about 2018 because I think that's when you started it out.
Yes.
In your 6 years at the department, you probably dealt with situations similar to this.
Yes.
You would agree that the way you did it is not as safe as calling out first to see if anybody will come out of the vehicle.
Right.
Because if you just open up the door and somebody's in there surprising you with a gun or other weapon, right, that's much more dangerous than calling out and having them come out.
Yes.
Would you agree that the mechanism in which you cleared this truck is not purely consistent with training?
Yes.
Believe that. Oh, no, wait, I do, sorry. We saw when you arrived, right? You obviously didn't see Mr. Krizenga with the gun prior to you locating the gun, right? Yes. In other words, you don't know if that vehicle was moving with him carrying the weapon inside the vehicle, correct?
Yes.
You don't know if he maybe tossed off a couple of shots, then placed it where you placed it, where we see it here on Exhibit A, right? Yeah. Nothing further.
One question. Hypothetically, had you called out, if anybody's in the vehicle, get out, and nobody had responded and nobody opened the door, would you have not done what you did here?
No, we still would have cleared.
Thank you, officer. No further questions, John.
I have a question. What is the process as you learned it in training for how to clear a vehicle?
For a situation like that.
Correct.
So first off, we would conduct a traffic stop. It'd be a little different. We'd have two vehicles almost right next to each other, almost nose to nose to almost create a V.
Meaning the suspect vehicle and the officer vehicle?
So the suspect vehicle would be in front of us. And then
Okay,
you'd have two patrol vehicles behind that, almost creating a V.
okay,
Then you'd have officers on each side in the middle. One officer would make announcements for the driver to step out of the vehicle. Once the driver's out of the vehicle, we give them commands to walk backwards towards us, up until a certain point of the officers feel comfortable enough to go hands-on with that subject. They would then detain that subject. We would then continue our call outs and announcements to the vehicle. Like if anyone else is in the vehicle, make yourself known, step out of the vehicle with your hands up.
Oh. But when you arrived, the suspect was already outside the vehicle?
Yes.
Okay, and I think I saw on the body cam where he was backing up.
Yes.
Is that part of the?
Yep, that's like the
Okay.
commands that we give them and then having them back up and walk backwards towards us.
Any cross or redirect based on my question?
No, thank you.
Anything based on my question?
As you were driving to the scene, there was no indication on radio traffic that there was more than one person. Is that correct?
Inside that vehicle?
There was more than one person involved, period. Inside or outside?
It was just the initial call. The original dispatch call. That was saying that there was a male with a firearm, and later he was shooting past them.
No other indication of anybody else with that male was the subject.
Yeah, correct.
May Officer Foot be excused?
Yes, thank you.
Thank you, you may be excused.
Officer, before you leave, can you just give me back that?
Yes.
No.
Our next witness,
People rest, Your Honor.
any defense witnesses?
The defense has no proofs, Your Honor, other than today.
For argument,
Thank you, Your Honor. The reason we're here today is for the count of, you said that's count 3, weapons carrying concealed. As previously indicated, the people are going to nominate counts 1, 2, 4, and 5. And then the people would also make the motion that count 6 accompany count 3 to the circuit court. People have the burden today to prove probable cause that first, that a pistol was in the vehicle that the defendant was in. The testimony offered by Officer Mosby and Officer Foote was that when officers arrived at the suspect vehicle, this pickup truck, there was nobody else present, and the defendant, identified by both witnesses, or I think identified by the first witness, was the only person present standing at the driver's side of the vehicle with an open door, and that nobody else was nearby. I think I misspoke. I don't think that my last witness actually ID'd this person, but my first witness did. The second, that the defendant knew that the pistol was there. In this case, Officer Foote testified that upon doing a clearing of the vehicle to ensure nobody else was there, there was a pistol in plain view. People offered People's Exhibit 1, which showed the pistol. The officer testified was a very accurate representation of how it appeared when the officer was there. And we could see in the body cam footage that was offered by the defense that without anything in the vehicle being disturbed, the officer actually took a photo. At the time, the pistol was discovered in plain view, sitting on top of an open case of beer in the passenger seat, front seat of the pickup truck. There's plenty of evidence in that manner that a reasonable inference can be drawn that the defendant knew that the pistol was in the vehicle in the passenger seat, a vehicle in which he was apparently the only person nearby. And also that the gun was out in the open. And then third, that the defendant took part in carrying or keeping the pistol in the vehicle. In this case, the witness, Officer Foote, testified that upon checking the registration of the gun was registered to the defendant by name. Therefore, with that testimony and with the registration of the gun in the defendant's name, there is more than a reasonable inference that the defendant took part in keeping the pistol in the truck in the front passenger seat of the vehicle, in which, again, there's a reasonable inference that no other occupant of the vehicle was present at the time that the defendant was present with that pickup truck. Therefore, based on a probable cause standard for the purposes of today's hearing, the people would ask that the defendant be bound over to the circuit court on count 3, carrying a concealed weapon in a vehicle, and we would ask that the OWI charge accompany the charge to the circuit court. Thank you.
Counsel.
Your Honor, I'd like to address two things. First, the search, and secondly, the elements of carrying a concealed weapon. Your Honor, I think overruled my objection on the search. The record I'd like to make is that if they're offering it as an exception to the warrant requirement on plain view, I just had a plain view case, People versus Champion, which is 452 Mich 92, 1996 case. There are many plain view cases in Michigan's jurisprudence, but number one, you've got to have a scenario where the officer moves nothing and it's completely divorced from any investigative goal. You want to use the fruit of a so-called interview search. Obviously, we don't have that here. We had to open up the door to observe this weapon that's at issue. I'll let the court refer to the court on what Exhibit A reveals, but to me, it's pretty clear that the windows are tinted. They wouldn't have been able to see that gun without it. The officer indicated that this was about officer safety and the safety of anybody else in the area. It is a caretaking function. The caretaking function has limited application. The caretaking function was not only not divorced from the investigative purpose of looking for objects like a weapon, and specifically a weapon. I think they were absolutely looking for a weapon. But here, he didn't follow the training. And it's obvious, it's much safer to say, hey, come out, law enforcement, anybody in there, come out. I mean, we've all seen those kinds of situations on body cameras, mobile vision recorder videos, where that's what the officers do. It's what they call verbal force response. That didn't happen here, and the officer frankly acknowledged that it was what they did was not consistent with their training. The other issue here is People versus Nimeth, N-I-M-E-T-H. There's no proof that Mr. Krasinga carried the weapon. We just know that the weapon was found on the passenger side of the vehicle associated to him. You have to have three things. You have to have, when you're proceeding on CCW in a vehicle, which is what I surmise is what they're doing here. It's not necessarily clear in the complaint. So the weapon in the vehicle, that the defendant knew that the weapon was in the vehicle and that he carried the weapon in the vehicle. The third element is missing. You've got testimony that the weapon was found, and that's all that we have on this record. Could have been placed in there 3 minutes or 30 seconds before the first officer, who I think was Officer Mosby, arrived. That's not carrying. It's simply not carrying. I object to the bind over on count 4. Obviously, count 6 would go to circuit court or stay here, depending on how the court rules. Thank you.
Well, with respect to case law cited with respect to a plain view search, obviously we don't want officers removing anything because that would constitute something like a search. But in this case, where the officers are opening the door to ensure there was nobody else in the vehicle, I think that would be applying that standard to a point of absurdity. The vehicle doors had to be opened in order so that officers could ensure there was nobody else inside the vehicle. With the vehicle doors open, it took no additional effort. Officers did not have to reach inside the vehicle or touch anything inside the vehicle in order to view the gun in plain view. So I don't think that case law applies under these circumstances. As with the argument that the officers did not comply with training, the body cam shows that, as the officer had indicated, when officers showed up and got out of the vehicle in order to do the safety clearance of the truck, officer, I think it was Mosby, was already asking that the defendant back up toward him. The officer's primary concern was for the safety of the officers. There was no search. And so what the officers did here, I think, is completely reasonable. And the question as to whether or not the gun was seen in plain view really goes to whether or not the officer's actions were lawful. And I think in the circumstances and facts and what we saw in the video, everything the officers did was both reasonable and legal. And so therefore, I don't think there's any argument, at least at this stage in this prosecution, as to whether or not the seeing the gun in plain view was the process of any kind of search, illegal or otherwise. Thank you.
Thank you. That concludes the preliminary examination or the proofs and the argument on count 3 only, as the other counts were dismissed by motion of the prosecution.
I said count 4, sorry.
I'm sorry.
I said count 4, I meant count 3. You're right. CCW.
Correct, carrying concealed weapon. Okay, and so, Mr. Kazinga, it's the burden of the prosecution to establish that they have sufficient probable cause that felony was committed and sufficient probable cause to charge you with the felony. It's a very low burden. It's more than mere suspicion. It's just not a time that they would need to prove each element beyond a reasonable doubt. Your attorney has made some objections as to the validity of the search. It's a separate issue. And then also the court will weigh the likelihood of the prosecution's success at the time of trial. We had testimony first, bringing us to the date of September 11th, 2024. Officers responded to the area of 624 Mercantile Way in response or dispatch to a possible weapons complaint. Officer testified that he drove around a building locating a silver Tundra pickup truck located the suspect outside the truck. He described it as a felony stop due to the possibility of a weapon complaint. He indicated that the defendant had slurred, or the suspect that he identified in court as the defendant had some slurred speech, that there was a wet spot on his pants, that there was a smell of intoxicants, and that the suspect stumbled as he was walking and his eyes was a little red. He stated under the circumstances he did not perform SFSTs due to the possibility of a violent crime or weapons complaint having recently occurred, that there was what he believed to be an accident and that they were not in a safe location or position to do those tests. He testified the defendant was called back to the patrol vehicle and placed in handcuffs. We then had testimony from Officer Foote, who was dispatched to arrive to the same location. He said he was again dispatched to an active weapons complaint and possible shots fired. He was not the first to arrive to the scene. When he arrived to the scene, he said that the suspect was already outside of the vehicle following a felony stop. He understood there to be the potential of a gun involved and that he was unsure if there was anyone else involved, particularly if there was anyone in the pickup truck. The court did see the defense exhibit A, which was the body camera of Officer Foote. I would agree that the windows were tinted and that you couldn't see inside of those windows. Also, it's a pickup truck. I'm not sure the height of these officers and if they could see through the window just by standing there. I couldn't tell you that. However, the officer testified that they had to make efforts to clear the vehicle to make sure there was no one else inside the vehicle. And due to those efforts, he opened the passenger seat door. And when opening the door, there was a firearm in plain view, seated on top of a Coors, like a box of Coors Light beer, which is reflected in the People's Exhibit 1, which shows the front passenger seat, a box of 12 count Coors beer with a firearm on top of it, which Officer Hood testified he took that photo at the time of the incident. Carrying concealed weapon requires that the prosecution establish first that the pistol was in a vehicle that the defendant was in. That we have sufficient circumstantial evidence that the defendant was obviously in this Tundra vehicle, that there was a stop on the vehicle, but officers testified the defendant or suspect was outside that vehicle at the time that they arrived, and that there was possibly an accident, possibly not. There was question about whether or not the damage to that truck could have potentially have happened at another time. And then we also have a photograph and body camera that shows a firearm or a pistol inside of that vehicle. Second, that the defendant knew the pistol was there. There was some argument as to whether or not the defendant carried or took part in carrying the pistol in the vehicle. Then obviously there was an objection as to the legality of the search. I overruled the objection, and I can appreciate a record being made for the purposes of protecting your rights for appeal. However, the officer, I think, was credible in his testimony as indicating the reason why the doors of the vehicle were open, and it was for officer safety and to clear, to make sure there was no one else in the vehicle. I don't know what the dispatch gave, or even if the dispatch didn't give any information that led to anyone to believe that there might possibly be someone else in the vehicle. I think it's common and natural and appropriate for an officer or officers to make sure that if they're arriving to the scene of alleged incident where there's been accusations or claims of weapons used and possible shots fired, and there's one person off the vehicle and we have tinted windows, you probably want to make sure there's no one else in the vehicle for the safety of those responding and in the area of the incident. So I don't think that that was unreasonable. Whether or not the officers gave or could have given a lawful command, and that would have been sufficient enough. I think that's a question for a jury, but opening the doors to see if there's anyone in the vehicle, I think were reasonable under the circumstances. And so that was the reason why the court denied the objection to the search or the opening of the vehicle, if that is to be construed as a search. And so I construed it more as a clearing of the vehicle. Officers opened the door, and when they opened the door, right there, there's a firearm on top of open alcohol, or a box of open alcohol in the front passenger seat, to which the officer took a picture of. Whether or not there's sufficient evidence to show or demonstrate that Mr. Kristen took part in carrying that pistol in the vehicle, well, no one else was located in the vehicle that found that a firearm or pistol was located that was registered to Mr. Kristen, who Mr. Kristen is there potentially under the influence of alcohol and later taken into custody in response to the dispatch. The court is satisfied that there's sufficient probable cause as to count 3, and count 3 will be bound over to the circuit court for further prosecution. Bind over date's going to be the 29th of January. You do not need to appear in court on the 29th of January. That's just the date the circuit court's going to get the file from the district court. Okay, Mr. Kristen? Your next date in court will be a pre-trial. And your attorneys will be made aware of that date, okay? Bond was originally set at 3,000 personal recognizance, and it will continue. The remaining counts count 6 will accompany count 3 to the circuit court. The other counts will be dismissed. I think we need a count for a dismissal for that. Any additional matters for the record?
No, Your Honor, thank you.
I do. Are we operating now under the auspices that I still have to waive his circuit court arraignment, or is it automatic?
It's automatically waived.
That's what I was picking up, but.
Yeah, it's automatically waived. You would have to now make a motion if you wanted him to be arraigned.
Understood. Thank you.
Thank you.
Thanks for your Zoom expertise.
No problem. Using it every day for the last 6 years. Okay, let's see here. We need to bring up. And we can return this one to council. This client is at work. Yes. And then what are we doing with, and Austin's client needs to be arranged. If someone can assist you, you can bring them both, but.
Oh. Addie?
Yes.
Can I sign for those, the transcripts for Mr. Muhammad? Thank you. Thank you. What year did I? You ever watch Mr. Golden? No. You ever see the movie Major League? John's outside. I can't remember. I recommend you look up those things.
Was it Snipes?
Pardon?
Was it Snipes?
He was, yeah, in the first one. And it was Omar Epps played Lunez A's in the sequel. No, Bob Beaker, he was in Chicago. Milwaukee, yeah. And he played baseball before that too, right? It's how that was. Yeah, yeah. That's it. He was 90. I didn't realize. I mean, it makes sense. Okay, man. Let's just talk about it's a big deal in my childhood. Hang on, you might recognize it. 80s. He's only 20 years old. 84, 40 years old.
On the record in the matter of the state of Michigan versus Maddie Horton, 24-01472. Council appearance.
Good morning, Your Honor. Matt Nagle for the people.
Good morning, may it please this honorable court. Yeah, Ms. Ford, you stand to my knee, right?
Okay, Ms. Horton has a preliminary examination that's scheduled for today. It's for carrying concealed weapon, motor vehicle UVA, and weapons. And my understanding, there's an unconditional waiver. Is that accurate?
That's correct, Your Honor. It's my understanding that the defense is choosing to waive their right to the exam. The people will do the same unconditionally. Also, it's my understanding that the waiver is in consideration of the offer that the people have extended. And that is that upon successful waiver and bind over to the circuit court, and at the time of the first circuit court retrial, the people would offer in exchange for a guilty plea on count 3 to dismiss counts 1 and 2.
We're gonna have to sign. Thank you. And that's a complete and accurate understanding of the offer,
Yes, Your Honor, it is.
ma'am?
Yes.
Okay, and you want to waive your exam?
Yes.
Okay, you understand the purpose of the exam is for you to require the prosecution establish sufficient probable cause that the felonies were committed and probable cause sufficient to charge you as the person who committed the felonies. You understand that?
Understand.
Are you willing to unconditionally waive your exam?
Yeah.
Anyone threatening you to do that?
No.
Any promises in exchange for a waiver?
No.
Okay, your bind over date's January 29th. That's the date the circuit court's gonna get the file from the district court. You do not have to appear in court that date unless your attorney makes a motion to the circuit court for you to be arraigned on that date, okay? Otherwise, your next court date will be a pre-trial and your attorney will be made aware. Do you have any questions?
No, ma'am.
Okay, bond was set at 5,000, 10%. Are we addressing bond?
Yes, Your Honor, I would like to.
You can proceed.
Your Honor, it's my understanding that speaking to my client, that she, they went to court and the bail bonds agency took her into custody. I asked the court to consider $5,000 personal bond. She does stay with her mom. She's not too far from the courthouse, but she does have the ability to make it to the Kalamazoo Street address for court. These are, non-violent offense, and I've always, and it's my plan to beg the prosecutor in a little better deal. I mean, possession of a taser, a non-lethal weapon, should not be illegal. In this case, she didn't use it against anybody. The police had contact because of some other issues that were going on in the neighborhood. She's talking to the police. She's holding a taser in her hand. I just think it's just inconsistent, hypocritical in the state of Michigan. Had she had a flamethrower in her hand under the exact same circumstances, that would have been legal. But to have a non-lethal taser in her hand is a felony. So based on all those, we ask the court to consider the bond reduction.
We'll leave it to discretion for you.
Bond is amended to 5,000 personal recognizance. I think the original issue was that you didn't appear for court previously, ma'am. Gotta come to your court dates. That's what the personal recognizance means. It means that we trust you to remember and to take it as your responsibility to get yourself back to your court dates. You understand that? And if you're gonna change addresses, you gotta let the court know, because that's where your notice is going to go. So you change addresses, it looks like from the time that you were arraigned until your next court date. You didn't come to the next court date. And then I think when you were arraigned, you told the magistrate that you couldn't stay with your sister anymore, so you moved. And I recognize circumstances can happen, but that doesn't mean you don't come to your court date. You understand that?
I understand.
Okay, so bond will be converted to personal recognizance bond. All other bond conditions will continue.
What address does the court have on file?
4101 Dorchester, apartment 1.
4113 Stacking Drive.
4113 what?
Stacking, Stackin Drive.
And your phone number?
517 894 8653.
Okay, do you have any questions about your bond conditions?
No,
You need to report to pretrial services no later than Monday, okay? Well, Monday's a holiday, no later than Tuesday, okay? You're all set.
Okay.
Thank you, everybody. Have a good day.
You too. That that is Mr. Holly. The record in the matter of the people of the state of Michigan versus Terrence Holly, 4-02773. Terrence, please.
Matt Nagel for the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Holly stands present to my right.
Okay, I have looks like a series of complaint for violation of conditional relief. Let's see. This is June 19th, 2024. June 19th, 2024. 2024. Could not be a conditional. I can't be a violation of this because the date of the incident was that date and this wasn't arraigned until September 17th. However, it looks like the police report indicates on the 13th of January. Officers made contact with Jessica Redmond at Eaton County Jail. Okay, I think this is. Okay, the end of the report, it alleges that on or about January 8th, Mr. Holly sent Ms. Redmond a message to the jail messaging system that said, you and Zoe don't gotta do this, them, N-word blankety blanks ain't going to kill me. They wasn't smart enough to get the job done in the street, so they manipulating y'all to put these bullshit charges on me, trying to send me to prison, so hopefully they can get the job done there. Ain't nobody eating off my head. You seen everything you know for a fact. They've been trying. You even wanted to call the police on them, put me in a perfect custody. Remember, y'all playing with my life and my freedom. I'll be straight in the world, N-word, asterisk, 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 ain't killing me. I promise you that. Then it states here on January 4th, 2025, Holly sent a message to Carl Morrison and said, I might beat this case too because the victim not going to come and it's only hearsay. Officer noted, it should be noted, Redmond did send Holly jail messages on October 17, 2024 and October 15, 2024, but both messages were pending still as of January 13, 2025. And Mr. Holly was arraigned on these charges on September 17, 2024. There was a no contact order in place indicating he could not have contact directly or indirectly with the Jessica Redmond. So the allegation that there was a message sent through jail messages, on top of it being completely ridiculous, that anyone from jail would send a message to someone they're not supposed to talk to via jail messaging. It's also a violation, if true, of bond conditions. And so you're facing contempt of court because of these allegations, and you could be punished with the maximum penalty of 93 days in jail for each contempt of court. Do you understand that? You have the right to have a contested hearing on the violation, and you have the right to be represented by your attorney at that hearing. I think you're scheduled for sentencing next week. January 24th. However, you have the right to plead guilty, plead not guilty, or stand mute as to the violation. How does he want to plead?
Your Honor, my understanding is that Mr. Hawley would be admitting to the violation, that he was in violation of the court's order by sending a message to the detective.
That's what you want to do, sir? It's up to you. Don't look at me. Is that what you want to do? Well, you don't have, you can think about it. You can put into a not guilty plea at this time. I'm gonna see you next week. What do you want to do? You want time to think about it? You were just arraigned.
If that's the case, Your Honor, then I would just ask for the court to set it for a hearing to coincide with his sentencing next week. Yeah, matters at the same time, presumably.
We'll set it for hearing January 24th at 9 a.m.
Your Honor, I believe I
I'm
received.
sorry. It's when? Oh, I do have a meeting in the morning, so we'll move it to 2 p.m. You had a question or something to say? Or you were gonna talk about that?
Yes, Your Honor, I was just about to say my understanding had been moved to the afternoon.
Correct. I have a state bar meeting at 9. So we'll do it at 2 p.m. Do you have any questions at this time, sir? Mr. Holland, do you have any questions? Do you have any questions about no contact orders or what that might include or entail? Do you have any questions about the recorded nature of communications in jail?
Well, don't say anything about.
I think I just melted, and I think I melted a little bit when I just happened. You pled not guilty. Okay. Any additional matters for the record?
Not for the people.
Nothing on behalf of Mr. Hawley. Your Honor.
Good luck. Thank you.
Thank you.
You're all set for today.